Hello friends, in the series on the income tax cases, today we will discuss a very important issue on contingent liability. The issue before the Supreme Court was that if some decree is passed by single judge bench to pay the interest and the assessee goes into appeal in the division bench and the division bench grants the stay on that decree. So whether in these cases it can be said that the liability of the assessee has ceased, or in other words, can the assessee claim the interest expenses in his computation of income even if the stay has been granted against the liability of the assessee. This issue has been discussed by the Supreme Court in the case of Commissioner of Income Tax and another versus National Agriculture Cooperative Marketing Federation of India Limited, and this case has been reported in 459 ITR page number 593. The matter has been decided by Supreme Court and the date of the judgment is 21st August 2023. In the present case, under section 5 of the Foreign Award Regulation and Enforcement Act 1961, the interest was allowed by the single judge, which was stayed by the division bench. The assessee claimed this interest in his books of accounts for the assessment year 2000-2001 and 2001-2002. The assessee who has filed the appeal in the division bench, the court granted stay against the execution of the decree which was passed by the single judge bench to pay the interest. When the assessment was going on, the assessing officer was of the view that this payment of interest is a contingent liability because it has been stayed by the division bench, because when the decision will come, it may come in favor of the assessee and it may come against the assessee. So if it will come in favor of the assessee will not have to pay the interest. So the interest expense should not be allowed to the assessee on the basis of contingent liability. The matter came to the CIT appeal. CIT appeal upheld the order of the assessing officer. The assessee carried the matter to the tribunal. The tribunal said that there is no legally enforceable liability to interest. The claim to interest is disputed by the assessee. The liability to pay interest is suspended by stay by the division bench. So the assessee do not have any right to claim the interest expense in case the liability of the assessee has been stayed by the division bench order. The assessee moved to the High Court against this order of the tribunal, and the High Court held that the stay would not revive the assessee of its obligation to pay interest. Liability arises in the year in which the decree is passed. So, in the nutshell, the High Court reversed the order of assessing officer, CIT appeal tribunal, and said that in the present facts and circumstances, when the single judge bench passed the order that the assessee has to pay the interest, so in that year itself, the liability of the assessee arises to pay the interest, even if the assessee has moved appeal to the division bench and the division bench has stayed that decree. It does not mean that the assessee is revived of his obligation to pay the interest. Friends, this case is very important. If we see in broader sense, then it appears at the face of the case that if the assessee himself has disputed the liability and is contesting his liability, then at the face the interest should not be allowed to the assessee, but the rule of law, because it has been confirmed by the Supreme Court that the liability arises as well as soon the order is passed by the court and the decree is passed. It does not matter whether that order to pay the interest has been stayed by the division bench or not. So the assessee has every right to claim the expenses in its computation of income for the assessment year 2000-2001 and 2001-2002. Friends, this case is worth reading. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax and another versus National Agriculture Cooperative Marketing Federation of India Limited, and this case has been reported in 459 ITR at page number 593. The matter has been decided by the Supreme Court and the date of the judgment is 21st August 2023. Thank you, friends.